Hello. It's nice to see you all again. I'm going to be doing this lecture, and I have another one in a couple of weeks as well. The lecture today is about one of the pending cases at the International Court of Justice. And you may be aware that I'm counsel in the case. About a year ago, I was approached by Myanmar and asked if I would join their team in the case filed against them by Gambia. So just bear in mind when you're listening to this that on the one hand, you have somebody speaking to you who has a very specialized knowledge, intimate knowledge of the whole case. But that, of course, I'm acting for one of the parties. And so you should just you should bear that in mind. And I also have to say that there are things about the case that I can't really talk about precisely because of my position. But I think I can give you a good introduction of the case. And when we have the class, you can ask questions, and if I can't answer them, I'll tell you. And if I can, I'll do my best to reply to them. So this is a case that was filed just about a year ago, exactly, by the Gambia against Myanmar. And there were some preliminary proceedings that took place. And excuse me a minute, I've got to turn something off here. There were some preliminary proceedings that took place, and the case is now at an intermediate stage, and I'll explain that all to you. It's not likely to end anytime soon. There are, probably years ahead of it before the case was finished. Cases at the International Court of Justice typically take a number of years to work their way through the proceedings. Here's a picture of the case. Of the proceedings. This is Aung San Suu Kyi, who is the head of government in Myanmar. You can see just over on the edge the Attorney General of the Gambia, who was there. And this is a picture that was in one of the newspapers here in the UK of the opening phase of the court. Aung San Suu Kyi attracted a huge amount of attention. Of course, she's a global human rights personality. She received the Nobel Prize for peace many years ago. And she lived in kind of under house arrest for many, many years in the capital of Myanmar, Yangon. And then finally was released and ran for election and was elected. She's not able to be the president or the head of state for some technical constitutional reasons, but she is, for all intents and purposes, the civilian leader of the government. And she did something that's rather unusual, was she agreed to come to the court and be the agent of Myanmar. This is very exceptional. There are a couple of earlier examples of heads of state coming to the International Court of Justice to represent their country, but it's rather exceptional. And of course, she stood up and spoke in the court, as you'll see in a few minutes. You can see here's the whole team, and there I am there a little bit along the line there, sitting in the front bench. And of course, we're all standing because this is when the judges came into the court. So this case is about the 1948 Genocide Convention. The Genocide Convention was really the first human rights convention adopted by the United Nations in 1948. It has a definition of genocide, and you've got it there on the screen. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. This is the definition in the convention, and the case is based on the convention, as I'll explain. So that means that if the court comes to the conclusion that genocide did not take place, it's not like a criminal trial where the court can convict on the basis of a lesser or included offense, that it cannot transform the case to other issues. In other words, if it concludes that the acts that Myanmar is alleged to have committed or be responsible for did not meet the definition of genocide, but met the definition of some other violation of international law, the court will simply have to withdraw and declare that reject the case and say that there's no other remedy possible. That's a matter for that's That's what the case. That's the limitation on the case. It's not the first time we've had cases under the Genocide Convention. I tried to make a list of them. It's hard to know exactly, it's hard to count exactly how many cases have been before the ICJ since it began in 1946. I think it's about 130, 140 of them, and probably close to 10% of those cases have involved the Genocide Convention. There was initially an advisory opinion to the court that concerned the entry into force of the convention, and that was issued by the court, the advisory opinion in 1951. And then there have been a whole series of contentious cases by one state filed against another, one by India, involving India and Pakistan in the early 1970s about Pakistani prisoners of war. Pakistan filed it against India. The case never went anywhere, and they finally were able to settle the case without having to litigate it. It didn't last very long before the court. And then there were some two important cases that were filed during the 1990s dealing with the conflicts in the former Yugoslavia, one by Bosnia against Serbia and the other by Croatia against Serbia. And both of those cases lasted for a very long time, about 15 years each, and ultimately ended in a finding by the court in 2007 that Serbia had not committed genocide in Bosnia, although the court said that it was responsible for failing to prevent genocide that had taken place when Bosnian Serb groups, over which Serbia was said to have influence, had committed genocide at the time of the Srebrenica massacre, which was in 1995. And then the second case was by Croatia against Serbia, also charging Serbia with genocide, and that was dismissed in 2015. And in the course of those proceedings, Serbia made what's called a counterclaim against Croatia, and that was also dismissed. Serbia, or as it was then called the Yugoslavia, in 1999, filed a number of cases against NATO countries, charging them with genocide when they bombed Serbia, what we call the Kosovo conflict in 1999. And all of those cases were ultimately dismissed. And then there was a case filed against Rwanda by Uganda, and that was also dismissed. These were more on technical grounds. They never got to the merits. But in the cases involving Bosnia and Croatia, the cases went to the merits. And so the International Court of Justice has now a very, very robust and developed interpretation of Article 2 of the Genocide Convention that essentially sets a very high threshold both for the evidentiary requirements of a genocide case. It says that this is not analogous to a civil proceeding where the standard of proof would be one of balance of probabilities, but that it's rather much more analogous to a criminal case where they don't use the formulation proof beyond a reasonable doubt, but where they talk about a very, very high standard of proof is necessary in order to have a finding of genocide. And they've also given this definition in Article 2, what I think it's fair to say is quite a narrow construction, whereby the notion of the intent to destroy the group means that you have to have the intent to physically destroy the group. It's not about cultural destruction, and it's not about driving people out of a territory where they have lived traditionally, unless you can demonstrate that that was associated with the intent to physically exterminate the group. So that's what the case is basically about. The jurisdiction of the court is based on the Genocide Convention. The Genocide Convention in Article 9 says, and you have the text here, the disputes between the parties relating to the interpretation of the convention or responsibility of the state for genocide is to be submitted to the International Court of Justice by one of the parties to the dispute. This is what we call a compromissory clause. You have compromissory clauses in many treaties. A compromissory clause means that the states to the treaty agree that disputes can be settled. Well, they can select the court where that will be done. In this case, it's the International Court of Justice. We also have compromissory clauses. We may not use the same term in contracts, and probably many of you, maybe most of you, have signed them, because if you have a lease agreement, if you have a rental agreement with a landlord, and you have you probably have a compromissory clause in there that specifies that disputes, for example, about refund of your security deposit or something, it will provide for the mechanism for that being settled. So this is more or less the same thing. Of course, it's possible for the International Court of Justice to exercise more general jurisdiction with regard to states that have made the declaration provided for in the statute of the court, whereby they make a general acceptance of jurisdiction. But that doesn't apply in this case, because Myanmar has not made such a declaration. And so the jurisdiction is based on the Genocide Convention. And so, of course, that just confirms the fact that if the court concludes that it's not genocide, it doesn't have the option to make a finding of some other violation of international law. One of the issues, of course, that's going to arise here is this. You can see it in the final words of Article 9, at the request of any of the parties to the dispute. So this is an unusual case, because and it may be the first case ever to come before the court that is a case where the applicant party is not really a party to a genuine dispute with the state, to the extent that it has been wronged in some way. This is a case of the Gambia acting, you could say, in the interests of humanity, or in the general interest, against Myanmar. They are countries that are geographically far apart. They have no particular issues in their bilateral relations. The Gambia has taken up the case. More on that in a minute. The factual basis of the case relates mainly to an episode of conflict in what's called Rakhine State in Myanmar, which is on the far western border. It borders with Bangladesh, and where there is a minority group that have, as the court has explained, self-identified as the Rohingya, and they're described as the Rohingya in the literature, in the activities of the United Nations, by many governments. Myanmar has consistently refused to recognize them as an ethnic group subject to certain rights under its constitution. So when civil conflict erupted, Myanmar is rife with civil war, and there are paramilitaries and military groups all over the country. It's a country that's just got conflict going on in many parts of the country. And in 2017, there were some episodes from a rebel group against the government, and the military went in and suppressed it in what the military calls a clearance operation, an anti-terrorist operation, according to the Myanmar military. And so the Human Rights Council in Geneva appointed a fact-finding mission to study this and report on it. And the fact-finding mission returned to the Human Rights Council in late 2018. And I've got the paragraph here. It says, in light of it's a lengthy report. You can read it if you wish. They say, the mission concludes that there is sufficient information to warrant the investigation and prosecution of senior officials in the Tatmadaw chain of command, that's the military in Myanmar, so that a competent court can determine their liability for genocide in relation to the situation in Rakhine State. So there, the mission is talking about prosecuting individuals, and clearly that's not the case that's going on at the International Court of Justice, which concerns state responsibility. But it did launch the idea that genocide would be the word that would be used to characterize the violations that are alleged to have taken place in 2017. And that gave energy to the idea that maybe there could be a case at the International Court of Justice. And so, of course, the first thing was to see who would file it. Bangladesh, which is a neighbor of Myanmar, was not in a position to file the case. And so finally, the Gambia stepped up and volunteered more or less to do the case. And that's how it got to the court. So Gambia is the applicant in this case. This is the technical term we use from the Latin is that it's acting erga omnes partes. It's acting as a party to the Genocide Convention, calling on Myanmar to respect the Genocide Convention. And so the theory is that Gambia doesn't have to demonstrate any particular interest. There was an earlier case dealing with an erga omnes obligation before the court under the Torture Convention, which has many similarities to the Genocide Convention. And under the Torture Convention, you have a compromissory clause. It's very similar to what's going on with the Genocide Convention. And it was Belgium that took Senegal to the International Court of Justice, claiming that Senegal was not respecting its obligations under the Torture Convention. So Belgium there was in a way acting erga omnes partes as well. But there's a distinction in that case. Belgium had asked Senegal to extradite the person who was charged with torture, a former dictator of Chad, who had found a kind of sanctuary in Senegal. And Belgium had asked to have him sent to Belgium, where they would prosecute him under universal jurisdiction, and Senegal refused. So then Belgium went to the International Court of Justice and said, look, they should either send them to us or prosecute them themselves. And the court ruled in favor of Belgium against Senegal, and Senegal later held the trial of Hissène Habré. And he's now serving, I think, a life sentence somewhere, I'm not sure, I presume somewhere in Senegal. So this is a little different because you can see in the Belgium versus Senegal case, Belgium did have an issue with Senegal because of its refusal to extradite him, whereas Gambia here has no real issue in the dispute, and that may arise now as a question in the litigation. Time will tell. Myanmar is what's called the respondent state. Myanmar received the application from the Gambia in the middle of November of 2019, and there was an initial hearing on preliminary measures, which I'll talk about in a few minutes. So they're the two parties to the dispute, and there have been indications from three countries, statements by the three of them, Maldives, the Netherlands, and Canada, that they plan to intervene in the case in support of Gambia. So I'm going to stop the recording now because I've gone on for long enough. And when we resume, I'm going to talk a little bit about the initiative by those countries and also about the preliminary measures question.